Oh, you brought a pad?
No, they
It's
gave.
hilarious that we sneak in now and do this.
Yeah.
That we're like the
No,
celebrity.
I think they turned
Celebrity
on.
panel. Yeah.
Celebrity bananas.
Peter's on. Oh, I guess we're all on.
My mic is hot. Sorry.
Okay. Hi, everyone. We're happy to welcome you to our final panel of the day. As I said, we're modifying this a bit on the fly, but I hope that this will still be a fruitful discussion and give everyone a chance to dig into a lot of the issues that have been introduced today. So we've heard from the artists and we've heard from the people who are distributing the content that the artists create, and now we're going to wrap up by talking about policy, right, and the government's role in this, and the Copyright Office in particular, and at the heart of all of this, the Copyright Act itself and the copyright laws and where we want to go with that. As I mentioned, what Registrar Pallante sent along in her stead today is a bunch of pages of written responses to some questions that I posed, which I'm going to share with us and get some reactions from a bunch of academics who spend a lot of time enmeshed in this area. And then we're really going to open it up and have a free-flowing conversation and questions between the audience and the academics. And if you'd like to pose some things in particular for Registrar Pallante, she is looking forward to the recording of this. So she said she's especially interested in the artist perspective and especially interested in the student perspective and folks from the industry and just users and consumers of content in general, which is an audience that the Copyright Office works very hard to get perspectives from, but that doesn't come to them as readily. So your feedback will be especially important in that way. So I'll kick off with something that's near and dear to my heart, and that is music. Last month, the Copyright Office released literally hundreds of pages of recommendations with regards to amending various outdated aspects of our copyright laws as they relate to the music marketplace. Music has a special place in my heart, not least of all because from an academic perspective, it's such a mess that it provides us really incredibly fertile ground for both critique and room for improvement. So before we dig into the content of those recommendations themselves, I wanted to start by giving the audience a little context of how these reports come to be. And so I asked what the motivation was for the Copyright Office to really research and compile and draft this Copyright in the Music Marketplace report. Maria says that among the many statutory authorities in Section 701, the Copyright Office is entrusted to conduct studies regarding copyright issues and other matters under Title 17. But the real question is probably why music? She notes that the Copyright Office administers the Section 115 license for musical works and reviews the rate-setting decisions of the Copyright Royalty Board under Sections 112 and 114. And we hear from the music sector and internet providers on a regular basis about music policy issues, including licensing concerns. And of course, everyday music creators register their sound recordings and their musical works with the Copyright Office. So music is a really important day-to-day aspect of the functioning of the office. As Registrar Pallante mentioned in her March 2013 Mingus lecture at Columbia Law School, it has been her observation in recent years that there's a level of gridlock in the music marketplace that is not serving creators, it's not serving those who support the efforts of creators, whether they be labels, music publishers, record companies, distributors, nor those who seek to make legal uses of music, especially in the digital realm. In addition to statutory music licenses, she has significant concerns with respect to these now 75-year-old antitrust consent decrees that govern both ASCAP and BMI, and how that form of government oversight impacts the music marketplace. There's this widespread perception that our music licensing systems are broken and unable to meet the demands of the digital age. So they really wanted to try to lay out the music landscape as a whole. Any thoughts from the panel on sort of why a good place to start with the next great Copyright Act, which is what the Copyright Office is calling for in the digital age, why music might or might not be a good place to start?
Well, I'll say something, I guess.
So I know at least there's several.
Well, I'm trying to be
experts on
polite
this,
and let the other ones go first, so I'll be rude and nod. So of the industries that have been impacted with the digital age in terms of revenue, the music industry is the one that's seen its revenue really plummet over the last 15 years. So 1999 record sales peaked, according to the RIAA, at constant dollars, if you put them in today's dollars terms, about $20 billion, and now they're down around $7 billion. So record sales have really plummeted, we've seen a radical shift in the way those revenues are earned. And so it's an industry that's probably been the most affected in that sense by the digital age. Movies, televisions, they've been affected, but their revenues have continued to remain steady and even grow. Books as well. And so in that sense, it's a good place to start. And also, it's sort of a hodgepodge of legacy rules, as you note, in the statute. Right? A lot of these things, as we heard on the earlier panel, the piano mechanical licensing is still in the Act. And the separation of the musical work and the sound recording copyright in the Act, and the different royalty rates and the different rights associated with them. A lot of it's just holdovers from an earlier time and not clearly thought through.
Yeah, I think that's right. The next thing I asked about was, so in gathering the information that the Copyright Office uses to generate these reports, who do they reach out to? How do they get the feedback? How do they know who to collect from, or what do they try to collect it from? Register Pallante said that they actually have quite formal processes in place for the collection of this. As with anything regulatory, they're bound by the APA. And they, as a general rule, also welcome comments from all interested parties. To solicit written comments or announce a hearing, they use the Notice of Inquiry in the Federal Register. The Register notes, too, that if you're interested in the Copyright Office and want to potentially contribute to these things in the future or know when calls for comments are coming out, you can go to the copyright.gov website, sign up for their Newsnet as a subscriber, and you'll receive this information. And she highly encourages folks who just want to kind of keep up with what the Copyright Office is doing to do so. Sometimes, she says, they'll even reach out to parties in advance to clarify issues or concerns as they're writing the inquiry that they're going to be responding to, including sometimes members of Congress, to see if they agree that the study would be helpful. Sometimes members of Congress are very detailed regarding the process they want to see, but in general, the Copyright Office tries to be highly transparent and will meet with pretty much anyone and everyone to review and include comments. When asked specifically about what they thought of the participation with regard to the study, she said that they were incredibly pleased. There was no disappointment with the turnout. If you look at the back of the report, she points to a list of study participants from a wide variety of parties, individual creators, trade organizations, tech companies, students, lawyers, and academics. They had representatives from consumer interest groups, including Public Knowledge and Consumer Federation of America, and they held a couple of roundtable hearings around the country to give an opportunity for other interested parties to permit this information. That said, she asked if we could take a break in the panel here, and actually wanted to solicit from you guys some suggestions on ways for the next report. They've got an Orphan Works, they've got a Making Available Rights report coming out. If there's other ways that the Copyright Office might engage with the public during these projects. So, she said, even if your ideas are budget heavy, pretending that they don't have those sorts of restrictions, what sort of ideas would you propose? Satellite offices, more roundtables, student events? Should we solicit papers? They want to know what they're not yet doing that you think they could be doing that would be more helpful. So to let some time to get the mic around, I'll start with you guys if you have anything, and then we'll take a couple solutions or potential suggestions from the audience, and then we'll move on down the line.
Well, one of the things I really commend the Register. Maria Pallante is doing a great job. She's brought a lot of new energy to the office. I think a lot of people, a lot of copyright scholars would probably agree with me about that, different energy from her than Register Peters. The openness to this kind of information is great. I think there's it's interesting. So, the U.S., so in 2013, the U.S. Patent and Trademark Office had their own green paper about these issues, music issues, so it's almost like the two IP agencies are competing with each other to say who can weigh in. Now, of course, Register Pallante would never say that they were competing or that there was any turf war going on, and none of that could ever be discussed publicly. But since she's not here, I'm going to say it. There's some kind of turf war going on that I don't think we completely understand. I'm not going to pretend to be an insider and understand it, but they each have their own process for trying to weigh in on that. There may be some difference in who, that the PTO is part of the Commerce Department, and that's just driven by a different set of political agendas. So I think but given that tension, one thing I think would be interesting is if, the PTO has been participating in lots of efforts in academia to get data sets out there, to work with academics. So in a really self-interested way, I'd be interested in the Copyright Office trying to help us figure, we lack the data to study these industries. Up here on the panel, the last panel, we just heard people complaining about, well, Netflix won't share their data. Well, yeah, I guess, lots of people won't share their data. It's proprietary for a reason. There's a legitimate thing, but there's also a need, like if we're going to study these things and if we're going to justify regulatory interventions or changes, I'd like that to be based on evidence. So it's not that I don't understand the importance of corporations protecting their data. I do. I understand why things are proprietary, but there has to be some balance, so that we can have any kind of evidence-based policymaking.
So the Copyright Office should fund your studies?
Not me. It was just, there should be the other, the other PhD economists who work in law schools who study copyright.
I think we have both of them on the panel.
Right.
I was trying to help you out.
Anyone from the audience want to offer a couple of suggestions on ways for the Copyright Office to gather this sort of information? Yeah.
Yeah, I'm a content creator, and I would suggest greatly reducing the term of copyright, because when the Founding Fathers came up with the idea, it was supposed to be for 14 years. And now corporate copyright can extend as long as 120, which is obviously ridiculous. But the gentlemen who were here earlier are able to suborn the Congress. And so I wonder if it's possible for the registrar of copyrights to override the Sonny Bono legislation and to reduce the copyright term.
Okay. Any other feedback for Registrar Pallante? I think there's someone up front here. She'll bring you a mic, but you're welcome to start. I'm sorry?
Facilitate dispute resolution.
Arbitration.
Okay, arbitration of disputes.
Or the small claims, ooh, this is really loud. Small claims copyright court? Yeah, right. Would that be that as well, or just?
One of the problems with the dispute one of the problems with IP dispute resolution is that the fact finders are by definition not knowledgeable in almost all cases. If you went to a small claims format, they'd be even less knowledgeable. You need to establish minimum standards of knowledgeability for fact finders. That's one reason why, because the decisions are so widely erratic that a party goes into it and can easily get blindsided. So, and if the Copyright Office, which is in a position to do so, is not willing to tackle that issue, it goes right to the core of the whole copyright system.
Thank you. The other call for information that she put forth with regard to this question is, she threw out that there's, like I said, there's reports coming out now shortly. There will be an Orphan Works and a Making Available. Going forward, there are other reports they'd like to work on. One they want to do is a study on moral rights, which is interesting because that came up in our panel and from a question from the audience earlier. So that is on her mind. They've also talked about maybe doing a comprehensive study of copyright law and computer code. And I know Professor Ohm had to go, but that's something else. So she would welcome thoughts, and I'll start again with the panel, on what next? Like what other specific areas of the copyright laws, we've been looking at music licensing, Orphan Works, Making Available. What do you think of moral rights or computer code or other topics? And if you could give a wish list of things you'd like them to do studies and reports on, what do you think is missing? What's not in the conversation right now?
Yeah, I think as somebody who was a songwriter and a musician before going to law school and selling out, right? Attribution is incredibly important. I just think for most artists I know, I think this was coming up on the panels before. The question was, protect the creation or protect the money stream. And so the oddest thing about our copyright system is it really just focuses on the economic rights. And so for musicians, I think that, and other artists too, they would really like to have some attribution right. Now I'm saying it's attribution because that doesn't have to be a full-fledged moral rights system.
Right, a modified sort of moral
Yeah,
rights.
and I wanted to flag, because Peter did bring this up in response to a lot of the discussions about moral rights / personhood interests from the creator's perspective, that it does raise significant freedom of expression concerns. So you see this a lot in right of publicity cases, and you also see it in the sort of the discussion of whether you want to have your work affiliated with the downstream work that whose creator you might disagree with. Right. So that might tie the hands of the Copyright Office with respect to that.
Yeah.
But we do have VARA, the Visual Artists' Rights Act, and it does try to tread this, narrow path between First Amendment plus attribution. So that might be a good model to start from if you're going in that direction.
Yeah, I like that.
Well, and it would be interesting to know, so, given one of the things driving the discussion academically about attribution is the experience with the Creative Commons license. So, Creative Commons offers these licenses that are, some rights reserved, not all. They're, sort of off-the-shelf, legal code that you can use. Some people are familiar with it. Lots of academics release their work under Creative Commons licenses. If you're familiar with Wikipedia pages, many of the photographs that are used to illustrate Wikipedia pages are licensed under Creative Commons so that they're free for non-commercial use. Almost everyone they used to have versions that didn't have attribution required as part of the license, and then versions that did, but so many people wanted attribution that they actually don't offer the non-attribution versions anymore. If you use a Creative Commons license, you are asking for attribution. It's so common. And so what would be interesting to know is where do we have attribution problems? Who's having trouble getting attribution, and who is not? You know what I mean? Because who found the Creative Commons experience helpful and was able to kind of enforce that, and who is that irrelevant to, and that would.
What type of creators are you having trouble potentially seeing your work somewhere else without your name attached to it? And we might say, well, that's trickier in this case of sound recordings because we'll hear your voice and we'll know it's you. But for composers, it might not be difficult at all for someone to take your song and sing it and have no way of tying it back to the songwriter, or a photograph for that matter. If I've not seen it before, I won't know whose photograph it is. Maybe there's some particular distinguishing characteristics, but on the whole, that can be challenging for those. Anyone else in the audience want to throw out a topic or two that might be worth the Copyright Office's attention? Hi.
Well, I see it quite fascinating that everything that I've heard today is pretty much a repeat of many panels that we've heard over the last 5 years. It's kind of like we're sitting in a repeat insane area. And it's also fascinating to me that everything that we covered today and talked about today has already been solved by technology that's out there in the space. In 2008, when the market crashed, the community that always innovates and evolves technology, the open source community, decided to create their own currency, because they felt like they couldn't trust the current economic system. This system actually addresses every single issue that we've talked about today. We've talked about licensing, we've talked about tracking licensing, we've talked about negotiating licenses in large volumes of licenses. We've talked about data, we've talked about privacy, we've talked about peer-to-peer trust, we've talked about trust in between peer-to-peer. And as a matter of fact, on January the 13th, Apple just filed a new DRM patent. But this DRM patent wasn't just a DRM patent for their iTunes music. It was a DRM patent for images, movies, pictures, music. It was for all types of digital media. And it wasn't just the digital rights management patent. It was actually a method and a business model. And so where we have been repeating the same and betting on the same business models over the last 5 years, the answers are sitting right in front of us.
So there is actually a great academic piece that's coming out, I think, in University of Southern California Law Review called Bit Property that tosses this, deals with this idea. So I'm really glad you raised it. I think that with respect to what the Copyright Office can do, that's a really valuable point because it suggests that there should be some sort of research, probably already embedded in certain reports, on the extent to which we actually need new law versus can look at what technologies are out there to do effectively what we want the law to do.
Right, I agree. I think that's a smart comment.
Hi, I'm actually not in law. I'm a PhD student in computer science and involved in building my own startup that revolves around music. And I listened to some of the facts about copyright law, of which I'm, like I said again, not incredibly versed. I'm kind of curious how it's going to take on some new technology, some of which that I'm creating here, which is I have no music ability whatsoever, but I am tremendous at mathematics and statistics. And I've been building machine learning models and artificial intelligence models based off of other artists' music, some of whom are in the room today. And what I'm capable of doing is not necessarily sampling in a traditional way, but I actually can build a mathematical profile for how artists create songs. Then I can blend those mathematical patterns together and generate brand new content that would be kind of an amalgamation of multiple artists. An example would be I could take a ska band and a rock band and come out with some sort of amalgamation of ska and rock combined together that's generated non-deterministically by the computer. But truthfully, the models are derived from and inspired by, but in my common sense computer science sort of mentality, it's not much different than someone really liking Nirvana, going in their garage with their buddies and creating new music. It's just I don't have that ability, and I've given that ability to the computer. So I'm kind of curious about how that would be impacted by copyright law, or the kind of things that are the impacts I could have.
There's been some fun stuff. There's two angles to this. One that people have talked about for a number of years is really kind of a cool puzzle of like, does the app get copyright on the new song? So forget about whether it's infringing, right? This is if you can have article.
Could I own it if I wrote my app and I generated the music?
Well, so that's what's been debated. Would you own it, or would nobody own it, or the machine own it?
And this is related to did everybody see the monkey
Yeah.
owning copyright?
Right, the monkey
photo?
selfie.
Yeah, so the monkey selfie is kind of a stand-in for that debate of like, can a non-human, I'm not kidding, can a non-human actually own copyright in something, or can the person who controls the non-human own the copyright in that?
So there's some important stuff there. And then on the other side of your infringement, it really is just going to kind of matter. And in fact, the way you said it, inspired by, I mean, it's kind of a case-by-case analysis. It depends if you're really just grabbing certain melodies or certain,
Mathematical properties.
Yeah, well, right, but I think he's saying he's blending it in a way. So we'd really have to hear the output, right? Because if it's just sort of inspired by it, it might be outside of it.
Well, I think, so there's the machine learning thing and authorship and ownership, which is an interesting issue for the Copyright Office to think about. I'm sure the Patent Office is thinking is starting to think about what they're going to do about artificial intelligence. And but then the second issue is just the scope of the derivative works right. I think, right, exactly, and it's obverse fair use. I think that's exactly, that would be an interesting study about how, what exactly do we think the scope of the derivative works right should be. The courts are kind of all over the place on it. There's a lot of different views of what the right even is. The treatises disagree about the scope of the right, whether it's coextensive with the reproduction right or whatever. So maybe there's an interesting issue about it, for these new uses that come up. What happens when, how do we think about that as being within the scope of the copyright? Because that's the right that would potentially be infringed by your work. And so it's just
that gives two potential angles to this. You could either have the report, which I actually had written down before you raised this, on artificial intelligence authorship and copyright law, which would deal with both the scope of potential infringement and the scope of potential exceptions from that. Or you could go a more holistic route and talk about how the difference between fair use versus derivative works right starts becoming really problematized when you talk about new technologies.
Yeah, that's great.
Hi, I lead an app development company that works on music education apps for kids, and I won't speak to our apps specifically, but I think apps are an interesting intersection of this digital and also creative expression. And if you look at the best games that come out, some of these most creative games, as soon as they get picked up or start doing well, they get ripped off. And either that's a program that jumps in and steals a bunch of the code, or sort of rejiggers it in some small way and then reskins it even to the point where it's extremely similar, or derives from it. And I'm not familiar with the derivatives, but I do know that code copyright is relatively ineffective, but apps as a creative work seems like an interesting place to protect, your game mechanism or your interaction, the experience that you create, and whether or not other people can just duplicate that.
Right. I think any comprehensive study of computer code and copyright that the Copyright Office may conduct would have to dig into gaming and apps as sort of even a starting point, if not like the central focus. So, yeah, I think that's right. We'll take the over here in the back. Sorry, make you run around. He had his hands up for a while, and then I'll start to push this along.
Oh, thanks. If I could just a couple of things on to just promote myself for a second here. I wrote an article in the Atlantic about called "When Robots Write Songs," and about these algorithms and how robots can create in the style of, allegedly, of like Bill Evans, the jazz pianist, or Bach or McCartney and so forth. And some say that it's actually more, if there's a legal issue there, it's more like a sound-alike case under Lanham Act. But a question that for registrar that I think would be of interest for me and others is Section 411 of the code is about it's the part 411. Part of that section is about how you need to register within 60 days of an infringement, or you're not going to get statutory damages or attorney's fees. It's very important because having been on both sides as an attorney, it's sort of like some have the attitude of, well, we'll just take, if it's not registered, we can just take it. And if we get caught, we pay the fair market value, or we pay the willing buyer, willing seller standard. And there are cases that support that. So it's sort of like a situation now of someone going into a supermarket, taking whatever they want and walking out. And if the cop comes and grabs them, they say, oh, okay, I'll just pay I'll go back to the register and pay for it. So I really think it's a concern that the registrar should look at about Section 411 and maybe examine the possibility of expanding that beyond 60 days to benefit some of the creators.
Okay, thanks. So the next sort of question I had was really more of a procedural question. It will come as a surprise to no one in this room that one of the biggest challenges for getting the next great Copyright Act going is the really endemic infighting among the interests in the industry. And so I asked the register, who does this report go to? You have your eye on a particular congressman or congresswoman who's going to be pushing this agenda. There's been some, the report, for those who've had a chance to look through it, even in the executive summary, it keeps emphasizing that we encourage the legislature to adopt these recommendations whole, not piecemeal, because piecemeal is going to result in these problems. And that this is the problem that music has, is that it keeps adopting all these piecemeal things, and what we actually need is a holistic approach. So, I asked her, tell me more about that, and what are the chances, right? So she says, we always give the reports to Congress before we release them to the public, so Congress is aware and have this first. Where it goes from there is really in the hands of Congress, starting with the House Judiciary Committee, which has taken the reins on copyright policy most recently, though the Senate Judiciary also has a very deep level of expertise on these issues, and of course has also received the report. There are several members. She names Goodlaw, Conyers, Nadler, Collins, Marino, Chu, and others who are specifically interested in this issue. And now that we're reaching the end, believe it or not, of the general copyright review process, it's going to be the chairman's decision as to how he wants to proceed on the music front. So far, the Register maintains very strongly that the piecemeal approach has not worked for reasons that she thinks obvious. Legislation aimed to satisfy one or some narrow group of interests at the expense of others is likely to yield, obviously, opposition. And so the report proposes a series of what they hope are balanced trade-offs where no one walks away with everything, but everyone seeks to gain something. In fact, in her main just lecture in the initial testimony before Congress last session, her message was that a more comprehensive approach is necessary to improve copyright more generally. And she says that if we look back in time, we'll find that there have been periods of piecemeal legislation followed by periods of comprehensive review and adjustment, and we're in that comprehensive period at this point. She finishes with saying, whether music legislation is possible is largely up to the music stakeholders. For them, an efficient licensing system is essential to their future success, but she notes that the music community is infamous for its political infighting. Songwriters, artists, music publishers, record labels always find it very difficult to agree on anything, much less a comprehensive plan, and notes that it's hard for Congress to make progress if they have a fractured community. When they presented this to Congress, Representative Nadler said, in so many words, the music industry needs to get its act together. Given the powerful interests it seeks to use and profit from music, including huge technology and telecommunications companies, not to mention terrestrial radio, the music community has much more to lose than to gain if they fail to agree on a comprehensive, holistic situation. What do you guys think?
Okay, so I have a couple of things to say about that. First thing I want to say is actually in relation to also to in response a little bit to the Bitcoin will solve everything thing. I guess that's right that these conversations, they go on for a long time. That's the democratic process. That's the process of analyzing our laws. That this is part. This is going to take a while. This process. It's going to be a long thing. I think that context is important, and that doesn't bother me. I don't want to revise the Copyright Act wholesale in a year. I don't know that it needs to take 22 years like it did last time, but maybe it will. Maybe it should. These are really difficult issues that are going to be constitutive of how creators create, how distributors shape our communications and media environment, how citizens live. There are issues that could become, the privacy issues that were raised on the last panel could end up becoming really central, in some of these things. It's very complicated, and I think that's okay. The thing that's a little upsetting about, so the Register of Copyrights in the Copyright Office has always existed in a framework that you just heard, which is that, well, we need to get all the interests and the stakeholders at the table, and then if they can agree, we can have a bill. And and I appreciate, one thing I really appreciate about Register Pallante is that I don't think that she favors any one of those interests at the table, and that's good, right? And that's, frankly, I think an improvement over some situations we've had in the past. But the
Names.
Yeah, right.
Not to name any names.
But I'm coming pretty close, and that's okay. But I think that at a certain point, our government, the Congress, the Copyright Office, the courts, they have to make a decision about which interest group is right, who has the just argument. Just because they disagree doesn't mean that one of them has the same strength of claim. And so to say that, we'll get a bill when they're ready, well, maybe one of them is going to be wrong and is going to be holding out. And we need to just say, okay, you're wrong. We're going to go with this other solution. And so to that extent, I don't want to wait for them to all agree. I don't think that's really the right standard. The right standard is to try and make the right policy, not to satisfy the interested stakeholders, not to get on a soapbox or anything, but that just seems to me to get lost sometimes in this discussion. I mean, of course, it's important to be informed by the interested parties, but I don't think it's right that they all have to leave happy.
Okay.
Well, I think two things. One is that the legislative process itself can nudge people along so they start thinking about their position. So they might take a page from patent reform, which took a number of years, but at least it's a different approach from waiting for the stakeholders to say what the bill might be. Instead, let's just dump a bill in there. And then that kind of freaks out a lot of the players, but everyone realized you have to get serious now because there's something in Congress. And then you start to narrow the issues. So again, if you look at what happened in patent reform, they narrowed, resolved some issues, came down to ultimately it was the damages stuff that was the last stumbling block. So you might have part of a process there. And then a little bit of a plug for us as academics is that when you have a situation like in music where the parties can be so far apart and they're afraid none of the extreme, I don't want to say extreme, but the stakeholders on the various sides don't necessarily want to dump out what might be a reasonable compromise. And that's something I think that we should challenge ourselves to throw those propositions out there because the stakeholders themselves might not put them out there. But if someone else says them, then you can start having a dialogue around them.
Great.
Just need something like we get in litigation. A settlement's a good settlement in litigation if both sides are unhappy. If one side walks away happy, then they got a big end of the stick. And
they got the windfall.
We just don't have that sort of process in the legislation, in the legislative arena. And so we do tend to wait. And sometimes we get really bad results when the interest groups agree and then they divvy up the pie that they've made it as large as they can for themselves. And that's another problem.
Right. So I want to shift gears a bit here. We're in a room full of people who have a strong and explicit interest in copyright. We have creators of content. We've got distributors of content and largely consumers of content, all of us, in many cases all embodied in the same person. So I want to start with the creator's perspective, and again, as we've been doing, I'll start with the panel and then welcome comments from the audience. As we saw in the first panel today especially, copyright's protections are not always that obvious to the creators themselves, for the people whom these protections are intended to protect, nor is its application consistent or predictable in a way that the creators can necessarily use. And one of the register's big pet projects here she really wants to focus on it and is looking for feedback on is how can we make copyright laws more accessible to artists? Mimi had mentioned, I can't ignore the money aspect of these things as an artist, but I just need things to be simple and clear enough so that I can focus on, content creation. I just want to do the creative side of things and have the other stuff not be so complicated that I can't do what I'm supposed to be doing. So I think that's one way to start. The Register gave a couple of possibilities, and then I'll welcome some others. She said, first, she thinks we should strive to write the law more simply. In more complex areas, technical details can be left to regulation so that the statute itself is easier to read and understand. Second, as the music report suggests, she advocates treating similar things in a similar fashion instead of having these multiple arcane systems like we've heard of today with the cover license and these musical rules. Let's treat things like. And she mentions, as by way of example, all music rate setting processes, in her opinion, should take place before a single body, in this case, her opinion, the Copyright Royalty Board, under a single rate standard. Finally, she says that we need to think about better ways to demystify and explain the law to creators, at least the parts they need to know about. And she feels this is not just the job of the Copyright Office, but also the job of creators and many of the students here who, the job of attorneys, and many of the students here will become attorneys, and others who work with these creators to help with the education process. And she notes some positive developments in this area in the last couple of years. Certainly, she's seen a lot more songwriters and other types of artists being more engaged and concerned about how copyright laws affect them and thinks that this is integral to the process. The Copyright Office worries about creators because they are the first beneficiaries under the Copyright Act, and yet there's no good policy rationale for asking them to subsidize the people and businesses who benefit from their work. Thus, she says, if there are not certain basic protections for creators in the law, it becomes too difficult to see how we're actually serving the public interest. Any initial reactions?
I can tell you with my clients, the most difficult issues that I have to counsel them on is the infringement standard, infringement and fair use. Right. We say it's the copyright, and so you have the right to make copies of your work, and at one time that was pretty clear. We meant the whole work, or pretty much all the work, in the exact same form, but that's not at all what we mean by a copy today. And so we talked about the computer-written songs that were inspired by earlier songs. How close they have to be before they become infringing is a very difficult question, and it's not something you can almost ever give a clear answer to your clients. So I don't know how we could expect the clients to understand that on their own if even with the counsel of a lawyer they still have to worry about what the jury might say.
Yeah, and it's also that the song or the movie is not monolithic in that, and I do a demonstration for my students frequently. I bring my guitar and I demonstrate how you write songs and then how you think about songs. And so, I show them some songs based off like a 12-bar blues pattern. I make the point to them that if somebody copies that 12-bar blues change underneath it, they're not infringing my song at all, even if my song is protectable. So this can be one of the hardest things, that it's not sort of one thing as the song. The other part, though, so I agree on the infringement, but I also want to put a plug for more education on the licensing part, because as Peter was mentioning with the Creative Commons licenses for other kinds of content, you can actually make up, in a way, you can get yourself almost an attribution right, because if you have the right to exclude other people from using it, you say one of the conditions is you give me attribution. And like open source licenses do on the software side, those can go downstream. It's not necessarily a perfect thing, but you have to be aware that you could do that until and unless we get an actual attribution right in there. So again, getting more education about how these licensing, what the power is that you have to craft different kinds of deals to get the right you want.
This might be a little bit far afield, but one thing that strikes me, especially from the conversation that was happening in the first panel today, is that it's not just a problem of education, it's a problem of a mismatch between artists' expectations of what a copyright is and what the actual law is. And education can only go so far when you actually have a mismatch in the understandings of what the system is supposed to do. So that might counsel, again, for reports on moral rights, et cetera. But parts of it are going to be unsolvable. And then the other thing I wanted to say was that the comment about having it be simple and then leaving a lot of things to regulation, I think is fairly optimistic about how regulation works. That's probably enough.
Right. I agree certainly with the expectations issue. I thought that one of the big takeaways from the first panel was that there is sort of an expectation that this is sort of the rights I have and this is what copyright does, and then there's the reality of what rights you have and what copyright does, and that is going to be, I think, the bigger the bigger challenge. So let's take some thoughts from the audience on ways to simplify the Copyright Act. There's a couple of hands up over here.
Right in the back.
Gentleman in the blue over here. Your mic is coming.
Hi. Perhaps one of the solutions is to have a separate copyright act for music and then for other types of content, because music, if you want an attribution right, it's not really compatible with a work for hire doctrine, but the work for hire doctrine doesn't really apply in the music industry, but it's critical for film and television, and it does separate us from the European film and television, and that's why our films are interesting and French films look like they do. And so the one solution might be to have separate acts for separate types of content. I was wondering if anybody thought about that one.
Well, actually, most of the world does, right? Most of the world deals with music under the related rights doctrine rather than under copyright. And I hope you didn't tell Sony that the work for hire doctrine doesn't apply in the music field.
Yeah, well, that's a story to be continued.
That's TBD, actually.
Yes.
But I think it's interesting. I mean, the fact of the matter is, like, so huge chunks of, the law is designed so that the rights granted, the 76 Act grants very broad rights in Section 106, and then has a very broad-based exception that applies to a surprising number of things in Section 107 that we may not have known about as of 1976, such as taping shows and watching them later. I don't know whether Congress had that in mind or not. We'll never know. But then Sections 108 through 122, those are all these ad hoc exceptions that build up. So Section 114 is like its own whole thing almost. So it's almost like we already have, and that's what this report reflects almost. But I think it's an interesting comment about like what we have. Is music copyright just its own thing? That is what a lot of people say to me since I do music copyright. They're like, you do that other thing, and I know about copyright. So
As somebody who does not do music copyright, he does that other thing.
Well, it's interesting. Well, it would, but and so this is a even larger policy decision. We've gone through it on the patent side too, trying to think about whether we should have different patent systems for different kinds of technologies. And at least the biggest break between biotech on one side, life sciences here, and information technology. And I'm always divided on that question. I think the challenge is if you do start separating them out, do they become so untethered that you might as well not even call them all copyright or all patent anymore. Maybe that's okay, but that's where you have to be ready to go.
And there are also comments that are made in the patent context that even though it looks like, kind of like
Right.
what you were just saying on the copyright, that even though it looks like we're addressing every technology in the same way, they're actually very specific subcategories of how it works depending on.
And exactly, and then if you look at the case law that then interprets it, you basically have, on the patent side, you have biotech cases. And so in the end, you get almost a de facto kind of separation. Well,
Well, it's a
Not
little
gonna
clearer
disagree
these
with you there.
days than it used to be.
Right.
Of course, you could have a simple fair use rule. I've always tried to propose this to my colleagues, but they've been resistant, right? Everything is fair use. Yeah, see, we got clear rules. If only the courts would adopt them.
And the settlement is going to be something nobody agrees on.
There you
Right.
go. Nobody's happy with.
So two other possible avenues I would suggest for making the law more accessible and understandable for creatives is one, an education, but not in the, maybe actually more in the traditional sense, especially those that for those who go to art school. I brought up earlier, and that's not the whole population, but I brought up earlier in the conference today that that's something that's part of art school that it doesn't exist. Creatives in art school aren't taught about business or law most of the time. So that's wildly overlooked, and that can be a cultural entrenched conversation. If they're brought up with the expectation of what the law is, there won't be that mismatch. The other, and this is a bit shameless on my part, is entrepreneurial, and that is we can capitalize on the startup culture, and I'm actually creating a startup right now to bring the law accessibly to creatives, especially in the state of Colorado. So if you want more information, please contact me. But I feel like that might be another of the best possible way to get creatives the content that they need around the law is to just, this is the United States of America, right? We're a capitalist engine. Might as well capitalize on it.
Yes, an economist would like to hear that. The markets will solve the
Well,
problem.
I mean, sure. Well, that's not, I mean, I'm a heretic economist, so I don't actually like to hear that. But I've been disowned, and I don't even have a card or anything. But maybe you still have your card. I think that the education efforts and the entrepreneurial efforts, the challenge will be what Glynn said earlier, which was really insightful about the infringement and fair use standards are so hard to teach. And I remember having conversations with visual artists while I was in grad school. You know, they said, "Oh, you're working on the sampling stuff, huh? Yeah, can you tell me about fair use?" And I was like, "I don't want to, actually." You know, this is in between the two famous Jeff Koons cases, right? And I was like, "I actually don't want to tell any of you what the court said, and I don't want to disrupt you. You know, I don't want to disrupt the process. Like the odds are so low that you would actually get sued. Like if you get that famous that you get sued, then we'll deal with it then. You know, but I don't want to interrupt, you know, what you're doing. I almost feel, you know, so I think it's a real challenge to present it in a way that isn't going to be, that isn't going to detract, especially on that front of infringement versus fair use, to detract from what artists are doing.
Well, I'm going to say that. So I hear you on that, but I think law schools have been traditionally pretty insular. You know, we were sort of our own place on campus, and we've been trying to integrate more. And so, you know,
They don't want us to talk to anybody else.
No, they do. They do want to. So I'm
They will
over at
infect them.
University of Washington, and I teach across campus quite a bit. I go over to, we have a DX Arts program. And so we actually do there a fun thing. We bring law students in with it. So the DX Arts is digital experimental arts. So they're kind of a combination of technology-based art, okay, weird kind of installation pieces. So we do a project almost every year where the law students come in, see the DX Arts grad students' projects, and then we have just a robust discussion. First about what are the legal issues. And it's not always just IP. It can be tort. It can be other kinds of things. You're going.
Why do you do that to them?
Because they're actually quite curious. They're quite happy about it. And then they help the law students think about, you know, is the law actually working in this way? So I think you can do education.
I'm just kidding, of course. I mean, I think that's great. But, you know, it's you hesitate when you have someone who's done something that's very much in the realm of appropriation art. You just start to get nervous. Like, are you going to get in this person's head and create this chilling effect? You know,
Right. By the other hand, so we did a project for one of them. There was a thing that was going to be an installation piece that the faculty at DX Arts wanted to do, and it was called Sanctum, and it was going to be this thing where you walk up in front of these TV screens, and there's cameras too, and they'll essentially record you, put you up on these big screens, and then they're tracking Facebook feeds, and also they're collecting a database of images, and they'll start showing you pictures of people who look like you. It's kind of the freakiest, creepiest thing, and so they wanted to do it. And of course, the UW said, "Hell no, we're not going to let you do that." It seems like all sorts of privacy problems, and so the clinic that I started, we worked with them, and we helped them, and the installation is in place. So this was, again, you can do these collaborative things. It's dicey, and you get nervous, and a bad thing could happen, but nothing bad did happen. So
you want education on teaching people how to monetize their content, i.e. earn a living, but you don't want education that's going to like stultify the creative process.
Right.
And I think that is the line that, again, there will be a settlement.
Right. So I want to, you know, we'll certainly people can email other suggestions. I'm happy to pass them to the registrar, but I want to, you know, keep us moving forward. So looking forward, another report that's going to be forthcoming is that the copyright will be considering the problem, if you want to call it that, of Orphan Works, which are works for which the author is not known or not readily obtainable. And this can create problems for good faith users of that content who have no one from which to seek permission, right? Leaving them to either assume the risk of potentially infringing or to forego use of the material altogether, thereby potentially denying we, the consumers, the enjoyment of whatever that work would have been. In short, Orphan Works for the system are major gridlock, especially in the digital realm, which is where these issues most often come up. And I asked if she could talk a little bit about the Copyright Office's approach to this problem, who they're talking to, what they see as the potential options for dealing with this, perhaps how other countries are handling it, and whether or not those approaches tie into the American system. So she says that the Copyright Office will be releasing their third report on Orphan Works next month, and she sees both a case-by-case scenario. That would be something like, I want to use one photo in a documentary film, but I can't get insurance if I don't clear it. And a mass digitization element, which would be which of these projects are in the public interest, which of them should be fair use, or there should be an exception, or should they be compensated. And this could be snippets, full text, for-profit, non-commercial, et cetera. All of the background's on the website, including the Federal Register notices that explain the international developments. And so I said, okay, well, many, if not most of the challenges for the Copyright Office today stem from technological development, right? And the shifts from analog to digital that have really antiquated. The 1976 statute would have been antiquated anyway by 2015, but really made it incredibly clunky. And as we've seen today, these changes in technology have both created challenges and opportunities in some ways for both creators of content and for the companies that distribute that content. So I propose that, but looking forward, I'd like to talk a bit about what the Copyright Office sees or hopes as the future of the Copyright Office itself, despite the partisan divide that we sometimes see in academia at least, and I think in the industry to some extent along sort of copyright and copyleft lines. One thing that everyone seems to agree upon, even in this room as we've taken questions from the audience, is that copyright, in a rather desperate attempt to stretch to accommodate technologies and scenarios that were never envisioned and could not have been envisioned at the time that the 76 Act was passed, the Copyright Act has become unnecessarily complicated and in large parts incomprehensible to the persons whose lives are increasingly affected by copyright. And so I asked for some thoughts on what she considers essential to this next great Copyright Act that the office has talked about, and just as importantly to the next great Copyright Office, because the report actually talks about a bit of reforms to the office itself, which I know my colleagues will have thoughts on. So I'll share her thoughts first, and then we'll turn it to the panel. So she says, as far as copyright law, there's a number of important substantive issues from her perspective: music licensing, orphan works, public performance rights, felony streaming, library exceptions, a potential small copyright claims court, and others that deserve attention from the copyright community and from Congress. She thinks that a guiding thing here should be that changes to copyright law should be forward-thinking, flexible, and in service of the public interest. That said, she thinks she's a very practical person and wants the Copyright Act to actually work. She says that she believes the Copyright Office is an important piece of the puzzle and needs to provide 21st century services that the copyright community wants and deserves, and ways that they've already begun trying to move the office forward. For example, during her tenure, she wants to bring in additional expertise from scholars and students. I know that my mentor from George Washington University, Bob Brown Eyes, actually was an intern there as an academic intern last year for the year and worked on registration issues. And he was the Kamenstein Scholar, which is what they started with, Kamenstein Scholar in Residence, and they're also starting a Ringer Fellow program. They've also created an academic research partnership. They started with Stanford Law School and are now working on new projects with additional universities that they'll be announcing soon. These programs are all on the website. They've created Copyright Matters, which is a public education event that brings in experts on a variety of topics from fair use to current copyright litigation issues. They've updated the Compendium of Copyright Office Practices, which is this huge undertaking, and it's the first time they've revised their practices in 30 years, as an important foundational project that allows them to really think about what the new paradigms for registration should look like. Likewise, she knows that the office needs to bring recordation online. Although she's very resistant to simply transposing the existing system into a digital interface. She wants to see a seamless chain of title, a real 21st century portal, interoperability with private data, and a system that befits a truly global marketplace. And notes that this is a big challenge, frankly, because although we want government leaders to be entrepreneurial, the actual business of government is slow. Budgets, sequestration, federal contracting procedures, et cetera. So as they were preparing for the legal research project that I mentioned, they also reorganized their business units to address certain under-resourced areas of the Copyright Office. For example, they set up a new Office of Public Record. And they've created deputies to take on some of the rather crushing workload in statutory interpretation, regulatory policy, and trade. They've taken a look at technology, and they have a project team headed by the office's chief technology office to issue a technical upgrades report with a variety of recommendations for modernizing their system. More generally, they hope that this next generation Copyright Office will be accessible, transparent, interoperable, efficient, and exciting.
Exciting.
Exciting. We haven't always used with the Copyright Office. What do you think? What do you think is essential for the next great Copyright Act and or essential for the next great Copyright Office that's going to implement that act?
Have we had a first great Copyright Act?
Just kidding.
When
The
was
new
the
great
last
Copyright Act.
Not so great Copyright Act.
Mediocre Copyright Act?
I think those are great. I mean, I think that's a great list of priorities. I mean, you can't maximize 7 things at once. You know, there may be trade-offs among those different values, but they're all good values. I mean, I'm interested to learn about these academic research partnerships and what they are. I guess there's not one at Northwestern, which is fine. But you know, I don't know what. I'm going to be very curious to see what kind of studies they're talking about, right? Like this recent report is a study that's about, you know, it's sort of like the process seems to be like problems we've heard about, and then sort of a theoretical, like we could propose this different structure. And I don't see where the place for like empirical evidence is, you know, in that. And I don't know if they're going to be partnering with people who are going to be getting access to data and doing empirical evidence like I was talking about before, or what they haven't, or not, or what they have in mind is just, you know, reports about, okay, this is the lay of the land, or these are some different ideas about how to resolve the interest group, you know, disagreements or whatever, which is all legitimate stuff. But I worry about, you know, Jamie Boyle in his book, The Public Domain, said that, you know, IP policy has been an evidence-free zone. And, you know, I think that's basically right. It's rare that there's been any evidence to support anything that's been done in either direction. Courts engage, you know, the courts who've decided so many important issues in copyright have engaged in a lot of casual empiricism, and not just in the Seventh Circuit, although they're the best at you know, making it seem very important when they make these casual empirical claims, but and very true, you know. But you see what I mean? I just think I just wonder where the evidence part is in those values.
Would you support having an office of a copyright chief economist, like we have in the patent office now?
I think there's been some good in the PTO doing it, you know. And no, I mean, I'm really not. I'm joking about the stuff about me. I just mean that they should collect evidence from someone. They're much better. There are economists in econ departments who are doing this kind of work. They should have Rahul Tulane. They should have Joel Waldfogel. They should have Mike Smith. They should have people who are working on this stuff, who are familiar with the data, do these things, and
give them access and let them
give them more access, and have the access not necessarily conditioned on you know, different kinds of partners or different kinds of data licenses. Yeah, I think that could be great.
Well, it is interesting.
I don't mean to volunteer Joel or Rahul or Mike. Maybe they don't want to go to Washington for a year, but they would be great, you know.
It's interesting in the antitrust area when two companies want to merge, you know, the FTC and Department of Justice get all sorts of information from them, very detailed information about market pricing, market shares, profits. And yet for years in the copyright space, people come in and say, we need more copyright, we need less copyright. And they really do just take it on faith. As long as the major interest groups on what should be both sides seem to agree on a solution, they'll push it through without any careful consideration or any real proof of what the parties are contending is the case.
Right.
Yeah, I think basically for me, another part I'd like to see is most is sort of interface and recreation, putting that online. And I think, you know, going back to the music thing, what I found, at least traditionally now, has been the number one confusion about people who are trying to, you know, register and deposit their stuff is that, you know, once we moved a number of years ago, so you could do a sound recording as your composition deposit, that still confuses a lot of people. They don't get that they still need to make sure that they are, you know, are they using that as their sound recording, or are they using it as a sound recording that happens to be the deposit, the registration for the composition? And if people don't know what that means, then that's part of the point of the problem.
Mm-hmm.
Oh, and one thing, I just quick interjection on recordation. I mean, you know, we didn't get to talk about this on the panel with Bonnie about recordation and the difficulties with formalities as applied to photography. I know that I've heard the registrar say herself at different speeches I've seen that she is sensitive to that issue. I'm sure she meant to bracket photography and the problems for photographers, because, you know, I think the Copyright Office has heard about that, is listening, is trying. I certainly hope they continue to, you know, pay attention to the difficulties, because photographers generate so many images digitally, and they're just issues that come up that are different for them.
Right. So there's a lot of other issues in here, but I think the best way, what I'd like to kind of present as our final big picture for both the panel and the group, because we do have so many students here and so many students involved and so many students interested in these issues. One thing I asked her was, you know, I wanted to take a minute to talk about what an amazing time it is to be a copyright lawyer, and you know, many of us on the panel have done it, continue to do it to some extent. And we hope that many of our students will. Some of the students were lucky enough to hear two of our panelist attorneys speak even today to talk about career paths in this direction and what it's like to go into a career that Could be entertainment law, or it could be something sort of tangential to that. So I asked her what she saw as some of the most interesting issues that young lawyers who are choosing to go into copyright law today might work on. And this is a little bit self-serving because I want a lot of you guys to take my copyright law class next year, but also because I genuinely think that in terms of considering what you might want to do with your careers, this is a fascinating time to be in copyright. So she sent a few of her thoughts, and I'll add some of mine, and you can get some from the panel. And then I hope that those of you who are in practice or have been can contribute some of your own stories, or not, to encourage our students to consider this. But she notes that obviously the internet, right, has provided a large number of novel and exciting copyright matters. So she would urge new lawyers to familiarize themselves extensively with the most recent technology and digital matters. Other than that, she said new copyright lawyers have this luxury of picking from so many interesting topics, too. There's such a breadth of material, from music licensing, which, as we can have discussed, can be incredibly complex and also interesting, to more traditional issues relating to protection of copyrighted works and novel ways of using works of authorship. Students always ask, well, do I need to be transactional or do I need to litigate? And I think that's a common student question. So she notes, I don't really think it matters if you start out on transactions or litigation or policy. The best is actually a combination of all three of these if you're going to be an efficient representative in this area. I think students should look for mentors, join the Copyright Society, which is a plug I forgot to make earlier. They were gracious in distributing information about this. And for student members, it's $25 a year, so you really can't beat it. Lots of networking opportunities. So join the Copyright Society, look for interesting projects, and be innovative about your careers. At the office, they love to encourage new talent. In addition to their law clerk program, which you should check out, they have recently created Ringer Fellow positions, which are geared towards exceptional new lawyers recently graduated from law school who are interested in a 2-year commitment to the office. In the summer, they have anywhere from 8 to 10 interns from various law schools around the country. Before they leave, the interns present their work to a senior legal team, and she said it's truly her favorite part of the experience because she realizes how fresh their perspectives are compared to the folks who are, in the office slugging this out day in and day out. Ultimately, the law students of today will evolve the copyright law because technology is really going to change their clients. She said she's recently hired young lawyers who have a very deep interest in technology, and in the case of the new Deputy General Counsel, even a degree in computer science. And she thinks this is going to be more and more often the case to the benefit of everyone. In registration, many of the staff have law degrees, and some of them also now have undergraduate degrees in music or in literature. And going forward, she wants to add lots more software experts. The area that I had brought up to her in a separate thing about antitrust and copyright, she thinks is also really exciting and important for people who want to sort of enter the copyright realm from the antitrust dimension. They're going to be looking on ways to reconcile efficient licensing and price fixing. And so I will turn it to the panel to see if they have any other thoughts.
Does antitrust now have its own parallel dimension?
Parallel dimension.
Yeah, they are, okay. I've always suspected, as I've read some of the...
Or maybe that's just the impression I've developed.
Sure.
Yeah, I mean, in my previous incarnation, being a law professor, when I was running a center, the Copyright Office had already started to reach out in these ways to indicate interest in engaging with new upcoming future attorneys who are going to end up being in this field. And I think it's incredibly encouraging, and all students in the audience should look into potentially taking advantage of those opportunities.
Yeah.
My experience has been that it's fairly difficult to work your way into entertainment law positions. Some of them are a little tricky. Most of the entertainment law firms, such as they are, don't come to CDO interview on campus. I have a variety of personal stories about how various students became various entertainment lawyers, including Suzanne Summers' manager, did the Thigh Master.
Yeah.
But it's a sort of hard field to make your way into, and the Copyright Office, actually working there for a while, can open a lot of doors for you.
Right. I tell students who come to see me that many of us who've worked in entertainment didn't graduate with the title of entertainment attorney, right? That I don't know if that ever happens. It certainly didn't happen for me. I put in my time doing mergers and acquisitions, and which basically consisted of discovery, and sort of some sort of template, negotiation, and then you just kind of you hustle and you meet people and you talk to people and you stay networking in the field, and you have a real genuine interest in what's happening, and then opportunities come up through people that you've met and you've networked with, and you take advantage of those opportunities and you kind of build on it from there. And I think that anyone you talk to who works in the copyright and entertainment arenas will give you a different but interesting sort of circuitous story as to how they got there, and it rarely involves them going to their on-campus interviews and getting a position as an entertainment attorney and doing that upon graduation. So don't be discouraged. You too can take that job in as a general junior associate in firm X, and develop your skills, whether they're going to be litigation skills, whether you're going to learn all about contracts. They're transferable skills, because even though the content, I think, in copyright is more interesting, you either know how to negotiate and draft a contract or you don't, right? And the content will change, but, you can sell yourself on those skills. And I think we had some comments here from folks who are in the field and practicing, and thoughts on, what it's like to work in copyright.
Hey, thanks. Actually, this sort of is also connected to what you were asking about before. But I'll say I'm not a professor. I'm a practicing attorney, but I spend most of my time educating clients about copyright law. I find that a lot of clients have to have they're artists primarily, and then like Aloe Black are essentially copyright attorneys as a second career. And I find a lot of my clients also in that position. I think if they're interested in it, that's great, but I think it's a little unfortunate that they have to be that versed in this, or that I have to spend a really huge amount of time educating them, and often when it's too late, when the infringement's happened, there's nothing we can do about it. This sort of goes back to the prior topic. I mean, for example, like the registration requirement of the Copyright Office, it's an expensive, but it's sort of a rubber stamp, but it's just enough of a rubber stamp hurdle to make things really difficult for people like A-Hole and other artists that are just unaware of this and aren't doing that. So.
Great, thanks. Any other sort of perspectives from the trenches?
Well, while we're finding someone, I mean, I think one path I hear about from students is they go to kind of an IP boutique. Maybe they do mostly patent, but they're ready to do the copyright. If they really want to, if their first love is copyright, they're just ready to do the copyright case when it comes, and then that kind of builds on itself. I have a former student who that's his story, and he seems he likes the patent work too, but he seems really satisfied with with what he's doing, because he was just sort of ready for the opportunity, the kind of opportunities you're talking about arising later.
Yeah, I think flexibility is definitely key. I mean, not only did I start just general corporate work, but even when I got on the entertainment side, I slummed it in film and television for a while before finally making it to music. But I think you kind of you follow your it's the end of the conference. So, and then you
still got to get out of this
follow your
room,
passion into the area in which you want to go. But you got to stay flexible. I think there was a hand up here. Hi.
Couple, either side.
I was just going to say I kind of followed the circular path into IP as well. I'm a fourth-year associate at a firm, just a general large law firm, and when I first started, it was in business and corporate M&A. And I've found that just really expressing an interest, especially as a junior attorney, to the partners you're working with, identify people in the firm that do that kind of work, and just acting excited and interested about it is enough that they'll take a chance and give you projects. And that's how I kind of got into it and learned a lot about trademark and copyright and just kind of general areas of IP. And I think just showing interest is something they find exciting.
Yeah.
And if you can actually be excited, not just act excited.
Even better. Not required, but.
I just want to mention a lot of the traditional communications firms in Washington also do a good deal of copyright. Sometimes it's cable related initially, but I started working in a law firm, and an old communications firm. We represented the Motion Picture Association, among other clients, in Universal, and I worked on a lot of, in fact, I even worked on the Betamax case a little bit, and worked on Computer Associates versus Altai and some other cases. that just, it's just kind of, that's another area that a lot of those traditional communications firms get involved in, especially on the video side.
Yeah, it's a great,
Nice point.
great point.
Thank you for that.
Yeah. Another comment over here. Okay, sorry, just 1 second, and I'll grab you next. Yeah, thanks.
As a shameless plug, the ABA has a book called Entertainment Careers for Lawyers, and it was just recently published. And so if students are interested in seeing it, it's got a lot of interviews of people who are in the entertainment business and how they got to where they are. So it's informative on that.
That sounds great. Yeah.
And I do teach copyright, and I think every student in law school should have to take it, actually.
But I have
From
one.
your lips to, yeah.
Might not be a particularly well-received comment in this audience, but there are also ways to be a copyright attorney that don't at all involve entertainment law. So if you end up working in law and technology, there are a number of firms on that far coast that deal with DMCA problems all the time. It's just from a very different perspective, and they are advising the companies that weren't here today.
Yeah, you can work for Google.
There's a comment up front here.
I have a question about the copyrightability. Copyrightability. First time I ever saw a hologram, I was a kid, and I went to Disneyland in Anaheim. And I've always been interested in the use of light, and especially holograms. And now, recently I read an article that images in light, which can be shut on and turned off, are copyrightable. What is your perspective on something like that? A 360-degree image, which at the flick of a switch could turn on and off.
Got 3 requirements for copyrightability in the United States. It has to be an original work of authorship fixed in a tangible medium of expression. So it has to be original, that is, it can't simply be a copy of someone else's work. It has to be a work of authorship, and Copyright Act has 8 or 9 non-exclusive categories that works of authorship generally fall in, and this sounds like either an audiovisual work or pictorial, graphic, or sculptural work. It has to be fixed in a tangible medium of expression. That means it must be recorded in some more or less non-transient form, and so as long as it's stored in the memory of the machine that creates the hologram, that should satisfy the requirements, I would think.
Yeah, I think that's right.
Not that I'm giving you legal advice.
I was just going to say.
Yeah, right.
It's not legal advice. And so I don't want to keep people from the reception, so I'll close with a couple of parting thoughts that Registrar Pallante wanted to get across, and we can continue the conversation with some wine and cheese. She wanted to note that the Copyright Office is part of a bigger interagency family of the government. They have traditionally worked with the Department of Justice. I'm doing
He's
this
laughing at
largely
the
for Peter.
fuzzy
USTR,
Best of
Commerce,
friends.
State,
Everything's smooth all the time.
and more recently the IPEC, and sometimes now with OSTP. Regarding the FCC, there's overlapping jurisdiction on certain issues, and in fact, during our recent study on phasing out certain statutory licenses for both cable and satellite retransmissions, the Congress assigned pieces of the project to both the Copyright Office and the FCC. During the cell phone unlocking issue of Section 1201, in which the proponents of an exemption failed to produce any evidence that we could use to renew the exemption that we had created in prior years, we suggested that in fact the FCC might be better suited to finding a permanent solution. One can think of other areas of the law where the 76 and the 98 statutes seem an ill fit. Indeed, when the DMCA was enacted in 98, even the software in our automobiles today would have been futuristic and well outside the realm of that. So leave you with those thoughts, and then we'll see you guys in the reception. Thank you again so much for making this such a great conference. I appreciate it.
The PTO isn't on that list. The PTO isn't on her list of buddies, though.
Sure.